Hello, welcome back. We're on Facebook Live again. My name is Matt Ormsby. I'm an attorney at Mountain West Disability, and today we are going to discuss what to expect at your Social Security disability hearing. I have some notes that I've prepared, so I'm going to go through those. When I'm done, if you still have questions, please write them in the comment section there on Facebook, and we will go through as many questions as we can. Also remember, you can go to our website, mountainwestdisability.com, or call us with any questions or concerns that you have. So first off, before your hearing, a few things are going to happen. Your case manager will call you and schedule a pre-hearing interview with me or another attorney, if another attorney is assigned to your case. That pre-hearing interview will be a phone call, and we will discuss, again, a lot of the same things that we talk about today, what's going to happen at the hearing, and I will be asking you questions about your file, your medical records, and you'll also have an opportunity to ask me any questions that you have before we go in to see the judge. On the day of your hearing, you'll want to make sure you arrive early to the hearing location, be there at least a half an hour early. Make sure that you bring valid identification to go through security. A lot of claimants, our clients ask me what they should wear to the hearing. There's no strict dress code. Obviously, I'll be there in a suit and tie. You don't have to dress up in anything formal or fancy like that. I want your clothing to be comfortable, not anything that will be distracting to you. The judge isn't really concerned with you, dressing up in a suit and tie. That being said, you don't want to show up in flip-flops and a tank top either. So nice clothes that are not distracting to you. Also, a lot of times claimants will ask me, well, should I take my medication before I come to the hearing? As far as medication goes, we do not advise you to do anything contrary to what your doctor has prescribed regarding medication usage previous to the hearing. So whatever your doctor has told you to do, whatever your regular prescriptions are, just do them as you normally do. People also ask about witnesses. Can they bring somebody to testify for them at the hearing? You are able to do that. It's something that the administrative law judge will allow. However, in my personal experience, I found that witnesses are generally not particularly helpful, and what I would prefer in most cases would be that you obtain written statements, signed, dated written statements from family, friends, doctors who might be able to describe their experience with you and your disabilities. Obviously, we'll talk about this on an individual basis before your hearing comes up. Sometimes it would be better to have a witness, sometimes it's better not to. If we do have a witness come to the hearing, they will wait in the waiting room while you testify, and then the judge will have them come in at a later point. If an observer does come into the hearing and hears your testimony, then they wouldn't be allowed to testify as a witness themselves. Another common question that I get about hearings is, will I get a decision that day? Typically, the administrative law judge will not give us a decision on the day of the hearing, and we do have to wait for the formal written decision to come out. That takes on average between 60 to 90 days. It can be a little faster. Sometimes it can actually take longer than that. So let's talk about the hearing itself, what's going to happen in the hearing, and this will vary depending on who the administrative law judge is. So I'm going to talk about a hypothetical hearing that has basically every component that may take place in a hearing. Some judges do very little, some do a lot more. We'll go into the hearing room together. We'll sit down at a table next to each other. There will be microphones in front of us because they record the audio portion of the hearing. The judge will introduce all the different people in the hearing room. Obviously, you'll be there, your representative will be there, the judge. There's typically always what they call a hearing monitor That's an individual who helps the judge with computer equipment, making sure the audio works properly, using the phone to call any witnesses that might need to appear over the telephone. There's almost always a vocational expert, either in person or on the phone at the hearing, and we'll talk about what that vocational expert does later. Sometimes there'll be a medical expert. Typically, if there is a medical expert, it will always be by telephone. Rarely they will be there in person, and we'll talk later also about what the medical expert does. So the judge will identify all of these different people. He'll ask you a few questions to verify your identity, name, social security number, address, phone number, and then the judge will put all the witnesses under oath. You as the claimant are a witness, and then there's the vocational expert and the medical expert. Those people will raise their right hand and give some variation of an oath to tell the truth under penalty of law or penalty of perjury. Once that happens, the representative, your attorney, will discuss with the judge a number of things, including the exhibit file, all of the different medical records and other exhibits that have been submitted. We'll talk about whether there's any outstanding evidence, records that we still need time to obtain. And then generally the representative will have an opportunity to give an opening statement. That opening statement is generally fairly brief, and we'll talk about the legal theory of the case, why we believe you're disabled as a matter of law. After the opening statement, we'll take testimony generally from the claimant first. Again, depending on the administrative law judge, they may want to talk to the medical expert first. Usually the vocational expert will always be the last witness. But we'll take testimony from the claimant, the vocational expert, and the medical expert. And then towards the end of the hearing, you may or may not be given an opportunity to make a statement of your own. It's not required. If the judge asks if you have something you want to say or a statement you want to make, you don't have to say anything. If you do want to say something, it's something that we should generally have talked about before the hearing, so that I as your representative know what you're going to say, and make sure that we're not going to say anything that might be harmful to your case. So that's in general a brief overview of what's going to happen in the hearing. The point of the hearing is for the judge to work through what's called the 5-step sequential evaluation process to determine whether or not you qualify for Social Security disability benefits. So I'm going to talk about those 5 steps and how they relate to the hearing a little bit. The first step that the judge is going to look at, and I said it is a sequential process, so the hearing may end when we get to a certain step if certain requirements are met. The first step that the judge is looking at is what we call substantial gainful activity. Basically what that means is, are you currently working, and how much money are you currently making at that job? In 2017, the monthly amount for substantial gainful activity is $1,170. So we're not really concerned with how many hours you're working, we're concerned with how much money you're making. And if you are working and you earn more than that SGA or significant substantial gainful activity amount, then you would not be found disabled because you're, in the government's opinion, making enough money, or too much money at least, to qualify for benefits. If you're not working, or if your earnings are less than what I'll call SGA, substantial gainful activity, then the judge will move on to step 2. And there at step 2, the question that the judge asks is, does the claimant, do you have severe medically determinable impairments? There's some keywords in there. They all have some very specific meaning. So severe means that your impairment interferes with basic work-related activities. Some of those activities, physical activities, would include things like lifting, carrying, standing, sitting, pushing, pulling, and then there's mental work activities as well. The mental activities are the ability to understand, carry out, and remember instructions, the ability to make work-related decisions and judgments, the ability to respond appropriately to coworkers and supervisors, and the ability to deal with changes in a routine work setting. So again, severe means that there has to be interference with completing those work-related activities. And the impairment then also has to be medically determinable. What that means is that your physical or your mental impairment has to result from anatomical, physiological, or psychological abnormalities that can be shown by medical techniques, by medical diagnoses, and clinical or laboratory diagnostic tests and examinations. The impairments need to last for at least 12 months or be expected to last 12 months or be expected to result in death. And then if you do have severe medically determinable impairments, the administrative law judge will move on to step 3. One other thing I wanted to say about the medically determinable impairments, in order to find those, we need to have medical records that substantiate your diagnoses. And every time you see me get on here and talk, I'm going to talk about medical records, because that's the most important thing for your case, is to have medical records that show diagnoses, tests, examination, diagnostic tests, physical examinations, mental health examinations that substantiate the claim that we're trying to make. So, step 1, you're not working at an SGA level. Step 2, you do have severe medically determinable impairments. We move on to step 3, and that's where the judge considers whether or not you meet or equal what's called a medical listing. There is a list of medical criteria put out by Social Security that's considered so severe that an individual will be found disabled if they match that criteria, or if they don't match it exactly. You can also equal that medical listing. Typically, to equal a listing, the judge would have to have a medical expert there to testify and explain how your condition would be the same as a medical listing. So if the judge finds that you do meet or equal a listing, then you're found disabled at that step of the process, and basically the hearing's over. If you don't meet or equal a listing, that's fine. It's not the end. We just move on to step 4. Now, between steps 3 and 4, the judge is going to determine what we call a residual functional capacity, and that can be either a mental or a physical or residual functional capacity, or it could be both. The purpose of the residual functional capacity is to determine your ability to work at steps 4 and 5. So the RFC, the residual functional capacity, is supposed to represent an individual's maximum ability to do sustained work-related physical and mental activities on a regular and continuing basis. And regular and continuing, that means 8 hours a day, 5 days a week, full-time work. The RFC, the residual functional capacity, is based on the impact of your medically determinable impairments, and it doesn't take into consideration things like your age, your sex, your natural physical or mental abilities, or even your current level of physical conditioning. So the judge comes up with this list of things that you can and can't do mentally and physically. That's your residual functional capacity. And then we go to step 4, and the judge asks, do you retain the ability to do any of your past relevant work? Again, that's a kind of a loaded term. Past relevant work means work that you have performed in the 15-year period before the hearing date. Also, work that you performed long enough to learn the responsibilities of that job. Each job, according to the government, has a skill level, and depending on the skill level of the job, you would have to work at the job long enough to learn the skills necessary for it. So, their simple unskilled work only takes a few days or a week to learn, but more skilled positions could take up to 6 months or even a year to work before the judge would consider that you performed it at a level that qualifies for past relevant work. Also, this work that they will consider has to be something that you've done at a substantial gainful activity level, meaning you had to earn enough money while doing that type of work for the judge to consider it. So we're at step 4. The judge figures out what is your past relevant work, and then given the RFC that the judge has come up with for you, does that RFC allow you to go back and do any of that past relevant work again? And they look at the way you perform that work yourself, and also the way the work is done generally in the national economy. Sometimes that's a little bit different. Sometimes you might perform a job where there's maybe a little more heavy lifting, but in the national economy, generally it's performed at a light level or a sedentary level. Vocational expert will be used and will be called upon to testify and to classify your past work. They will consider the work summary that you provide, as well as testimony that you give about your previous jobs. And then the ALJ, the administrative law judge, or the vocational expert might ask some additional questions just to make sure that everybody understands the responsibilities that you had at your particular jobs. If the judge finds that you can go back and do the same type of work again, then you would not be found disabled, and the hearing would end at that point. If the judge decides that you can't do any of your past relevant work, then we would move on to step 5. And step 5 is, are there other jobs in the national economy that the claimant could perform given the residual functional capacity that the judge is considering for them? And they do consider factors such as, whether you're able to make adjustments to that type of work if it's a new type of work, and there would be some limiting effects, including your impairments, your age, your education, and your work experience. So during steps 4 and 5, the administrative law judge is going to be talking to the vocational expert, first off classifying the previous relevant work, and then asking the vocational expert what we call hypothetical questions. So the way this works, the judge will describe what we call a hypothetical claimant to the vocational expert, someone of your same age, education, with your same previous relevant work, and then the judge will describe the residual functional capacity that he or she believes you're capable of. Typically, there will be a number of different hypothetical questions. The first hypothetical question with a lot of judges will be based on Social Security's initial denial of your claim. So some claimants can get a little bit nervous when that first hypothetical sounds like somebody more capable than they are, and the vocational expert starts listing off lots of different jobs that person could still do. Don't worry about that. The judge typically always asks a series of hypothetical questions, and your representative can also ask questions, can ask their own hypotheticals. Typically at this point we would like to incorporate any opinion evidence that we've received from your treating physicians, psychiatrists or psychologists, to see if the restrictions or limitations that they have placed on you would disqualify you for full-time work. Once the vocational expert has finished testifying, basically the hearing's over. Again, I said that the judge might give you an opportunity to make a statement, to bring up anything that we may have missed or not talked about. By this point, really everything should have been discussed already. Your representative should have brought up anything that would be relevant to that discussion with the vocational expert by that time. And then the hearing ends, and like I said, typically we don't get a response or an answer. Sometimes the judge will tell us what they're going to do. Even if they do give us their decision in person at the hearing, it's not official until we get a written decision from the judge. And typically that takes 60 to 90 days. It can be a little faster. Sometimes it can even take longer than that. In some instances, the hearing will have to go into what they call post-development. That would be a period of time that your case remains open for further development. Different reasons that may have to happen would include if there's medical records that are missing or that the judge thinks are important from a recent examination or appointment that you've had. We might be given time to go back and get those records. The judge, in some instances, will order a consultative examination to happen post-hearing, where you would go and see a doctor or a psychologist selected by Social Security for an examination. Or sometimes the judge might decide that there's need for a medical expert, and instead of bringing a medical expert in, they could send what are called medical interrogatories, or just questions for a medical expert regarding your capabilities, your diagnoses. With any of this post-hearing development, the judge will give us an opportunity to respond to consultative examinations or interrogatories, and there may be an opportunity to go back for a supplemental hearing to discuss any new findings that come up. When you receive your decision, you can have a number of responses from the judge, and they're what we call either a favorable decision, a partially favorable decision, or an unfavorable decision. Favorable and unfavorable are pretty clear. That either means you are granted benefits or not granted benefits based on the onset date that you allege in your application. A partially favorable decision could mean that you are receiving benefits only for a limited period of time, what we call a closed period of disability, where you were disabled, but after some point there was medical improvement and you were able to go back to work. Or it could mean that you are granted benefits, but not on the particular date that we allege you became disabled, but the judge may decide that your disability started, or at least that the medical evidence was substantial enough to show a disability on some later date. If you get an unfavorable decision, we have the opportunity to appeal that decision to the Appeals Council. You can also appeal a partially favorable decision if you believe the judge made some kind of error or mistake, and we'll talk about that. You'll talk about that with your representatives and decide what the best course of action is for you based on your case and based on what the judge's decision says. So after you receive the hearing decision, if it's a favorable or partially favorable, you will receive another letter a few weeks later called the award notice. That award notice is going to tell you more specific details on how much your payments are, when they begin, and typically you'll also get a phone call from Social Security. Well, they'll want to do a short interview with you and make sure you're still eligible, that you haven't started working, or no major circumstances have changed for you. So that's the hearing in a nutshell. I have a few tips that I wanted to give you, and then also a few problems that I see at hearings sometimes. So just a few little tips. Make sure you are there on time. You never know what could happen. Bad weather, bad traffic, you might forget your license. So just make sure you give yourself plenty of time. Also make sure you know where you're going, where the hearing location is. Some people will go to the local courthouse thinking the federal courthouse is where the hearing would be held. The hearings are always held at the Office of Disability Adjudication and Review, which can be in the federal courthouse, or it could be in a federal building, or it could be in its own separate office. Just make sure you look at that hearing notice, go to the address on the hearing notice. If you have any questions about it, call us and we'll help you make sure you're going to the right place. Try not to stress out. This is your opportunity to go in front of the judge to tell him or her what's happening in your life and why you're not able to work on a full-time basis anymore. But these hearings are what we call non-adversarial proceedings. So there's nobody there from the government trying to stop you or prevent you from getting your benefits. They're relatively informal proceedings. The rules of evidence that would apply in a typical civil or criminal trial are not applicable here. It's very much more of a laid-back situation. The judge understands that you do have mental or physical health problems, and you'll be allowed to stand up, to move around as you need to be comfortable at any time during the hearing. If you need to talk to your representative in private, that's fine. You can step out of the room and do that. You can take a break. Whatever you need to do, just be vocal. Let your representative or the judge know what your needs are. Last thing I want to say as far as tips go, make sure that when you are answering questions that your answers are verbal, that you're actually saying something. Responses such as head nods or saying are not really easy to understand, and they're not always picked up properly by the audio recording. So, for example, if the judge is asking you, can you raise your right arm above your head, you don't need to, and you shouldn't actually try to do that in the hearing. Just tell the judge, no, I can raise my right arm, shoulder level, but that's as high as it can go, for example. A few problems that I've seen at hearings before. Again, I'm going back to medical records. Sometimes I get into a hearing and the claimant will tell the judge about a medical provider that they've been seeing, and I've never heard of this person before. So be very sure that your representative knows about all your medical providers so that we can get all the medical records in the file in plenty of time before the hearing. Also, sometimes the judge will ask something like, how long do you feel like you can sit before you need to get up and move around? Well, if you're going to answer, I can sit for 10 or 15 minutes and then I've got to get up, but we've been sitting in the hearing for 30 or 45 minutes already, you can see where that might be a problem for the judge. So don't try to be a hero. Don't sit still through the pain. If you need to get up, get up. If you need to move around, do it, and make sure that the answers you're giving are appropriate and are not any sort of exaggeration. And one more example on this, and these are not things that happen very often, but sometimes I think claimants get a little excited and might want to do whatever they can to help their chances, but I want to make sure you understand we need to be completely upfront and honest with the judge. So, for example, if he says, tell me about the pain you experience on a pain scale of 0 to 10. 10 is pain so bad you have to go into the emergency room. What is your average pain like? If you say my pain is at a 10, well then we need to have emergency room records that substantiate you've had that extreme level of pain in the past because you've had to go in and do something about it. So that is, I think, everything I wanted to talk about with the hearing. And now we're going to see if anybody has any questions. I'm going to try and do it by looking at my own Facebook today. If not, I'm going to have Mandy tell me the questions. Let me just refresh for a minute. Well, I'm not seeing any questions.
We just have the one.
Okay, so far I think we just have one question.
And it just says, I've been denied. Should I reapply or go through by myself or go through us?
So the question is, I've been denied for my Social Security application. Should I reapply by myself or should I get help through someone like you? Obviously, I think it's important that you get as much help as you can. This is something very important to you and your family. It doesn't cost you anything to take on representation. Your representative will only get paid if you get paid, and actually will only get paid if you get back payments. So it's in your best interest to get as much help as you can. I would definitely recommend finding a representative, an attorney that you feel comfortable with, and going over that application, that denial with them to decide on the best course of action, whether to appeal, to file a new claim, or whatever is in your best interest.
Okay, that's our only question. You obviously did a good job.
Okay, we don't have any other questions right now. It was my goal to try and be thorough, to answer all the questions you might have. Again, if you're looking at this later on, if you weren't able to watch us live, and you have additional questions, please feel free to call us or email us, and we're here to answer your questions and to help you. Thanks, everyone, and we'll see you again later.